aspects. So I'm hoping to hear, hopefully not too much agreeing. I heard a lot of agreeing in the foyer, so I'm hoping we do find a little bit of dissent over the course of the day as we come into these. I mean, these are very difficult times and they're troubled times, and we're talking about difficult issues. Our first panel for the day in the Israel-Palestine Arrest Warrant Review Summit. So generally across the day, we're going to be interrogating the ICC's new arrest warrants that are coming out against Benjamin Netanyahu and Yoav Gallant, and also the leaders of Hamas. But the first panel is going to focus primarily on the legal grounds for these ICC actions. And we have a really, we're very privileged to have the panel that we have here. I'm very privileged to be putting questions to everybody. Over to my far right, we have Jeffrey Robertson, KC, the founder and the joint head of Duddy Street Chambers, a barrister, academic, author, if you will, who's worked on many extremely important cases. He's represented Julian Assange, represented Salman Rushdie, off the top of my head. Who else? Lula, the president of Brazil.
Mike Tyson.
Mike Tyson, of course, the most important one, Mike Tyson. So we're very happy to have him here. Over online in the digital sphere, hopefully we've got you here, Silvana Abia, the former chief of prosecutions at the ICTR, former ICC registrar, extensive experience in international criminal justice administration. Silvana, are you with us?
Yes, hello. Good morning.
Good morning.
Everybody.
Okay, fabulous to have you here. To my immediate right here, we have Dr. Didem Dogar from the Tilburg Law School, an expert in international criminal justice, who we were speaking over dinner last night. So I think this is going to be has lots to say. I think it's going to be extremely interesting. And over on my left, a wonderful last-minute addition to this panel, Professor John Cooper, KC.
The Ollie Watkins of the panel.
The Ollie Watkins of the panel. 25 coming in to score a final goal at the last minute. 25 Bedford Road Chambers, you might know. He's, again, worked on all kinds of very illustrious and interesting cases, perhaps represented the majority of the bereaved families in the Manchester Arena bomb inquiry, amongst many other important cases. So it's very exciting to start the panel. I think because we have rather a lot of time to go through, I guess we can kind of start maybe at the top. I mean, okay, Jeffrey, just the other day, you published an article in The Guardian, quite a strong, firmly worded opinion article about the UK's interference, perhaps, in arrest warrants. Did you want to maybe just...
Well, I could work it into an outline for the session that I've been asked to present, because these arrest warrants are in some ways unprecedented and of great importance. I think that the prosecutor, Karim Khan, is doing what is expected of him, doing his duty, but others take exception. He did his duty some 6 months after October the 7th, by which time there'd been some 30,000 at least deaths, 15,000 of them of children, bombed and found lying beneath the rubble of Gaza. How could the world turn its back on such a scourge of war, to adopt the phrase of the United Nations Charter Preamble? Well, Karim Khan went to Gaza, or tried to get into Gaza, shortly after October the 7th, and was not allowed in. That was the first act of Israel that is questionable in relation to these warrants. However, he claims, an interesting claim, to have witnesses to the crimes that he alleges from inside the IDF, from all sorts of first-hand people providing first-hand evidence for the serious crimes that he alleges. Two of them, if I can shorten them, one of starvation, deliberate starvation of the citizens of Gaza as a tactic of war, and secondly, of indiscriminate bombing. So pressed against Mr. Netanyahu and Yoav Gallant, his Minister of Defense. Is it important? Is it necessary? Is it frivolous for these very grave crimes to continue, and how can they continue the ICC as presently constituted? Well, the first criticism, there were political criticisms. Let's begin with Joe Biden, who described them as absurd and as, I forget which of the particular adjectives he used of the prosecutor. They were different to the adjectives he used last year when the very same prosecutor indicted Putin. That was wonderful as far as the Americans and the Biden administration was concerned. But this time they were severely criticized. One or two other states in Europe, Czechoslovakia in particular, criticized. I think Havel would have turned in his grave as the Prime Minister of Czechoslovakia that criticized the ICC. And from Britain, you had some very wishy-washy criticisms. Unhelpful, I think, was the criticism of the British Prime Minister as he was sliding away into disappearance at the elections. So the question there arises, I suppose, as to whether it's right for politicians who would not dream, because of their local laws and traditions, of criticizing the director of their own prosecutions for a particular prosecution, having no shame about doing that in relation to the ICC. But that is not our focus today. Were the arrest warrants correctly sought? Well, I think there have been two criticisms that need answering. One is wrong to come at the same time. Warrants against the Hamas leaders, two warrants against the Israeli leaders. This, and I don't think Karim Khan actually said this. I think it was Blinken who first said, this means there's an equivalence between Hamas and Israel. How dare this prosecutor suggest that there's an equivalence? Well, that could have been avoided and should have been avoided, in my view, by issuing the warrants against the Hamas leaders first, some months ago, because their guilt of mass murder of civilians, their guilt of taking hostages contrary to the Geneva Conventions is pretty obvious, and I can't see, subject to identifying them as in a command position, how they have a defense. And I can't see why. I think it would have been better if the warrant against them had been issued as soon as they had been identified. But of course, Karim Khan is not saying or suggesting that there is any equivalence between the crimes. What he's saying, in a sense, and what is right, is that we no longer live in a world where there's victor's justice. We have justice for all parties in a war. That was first, I think, established by David Crane, who was prosecutor of the court that I presided over in Sierra Leone, where he indicted not just the horrific criminals of the RUF, but he indicted the minister who had led the government forces and largely triumphed. I mean, the minister who had set up the government army and was principally responsible for its victory, was indicted because, unfortunately, in the course of doing this great work, he had recruited child soldiers. So he was prosecuted, and I remember as he was brought to prison, the prison guards all saluted him. But it was established that the principle that in dealing with a conflict situation, the prosecutor must not only provide justice for the victors, but justice for the losers, justice for everyone. And I think that was the principle that Karim Khan was trying to get across, but failed in many cases, with people accusing him of somehow suggesting that there was an equivalence. There certainly wasn't, and he didn't suggest it, but it was one of those unfortunate results of a tactic that actually could have been avoided. The other criticism that I don't think has weight, but others do, is that it breached the complementarity principle, which I'll assume you all know about, namely that the ICC is a court of last resort, and that only when local prosecution is out of the question does the international court prosecution come in. Well, that's certainly true up to a point, because the Israeli leaders were not given an opportunity for what? To prosecute themselves. This may be a change or a refinement of the complementarity principle. But the idea that Mr. Netanyahu would be investigated properly and fully by an Israeli authority and prosecuted, if need be, for starving people, attempting to starve people to death, is pie in the sky. We all know that. As a matter of practice, Israel never prosecutes after Operation Cast Lead in complaints against the IDF. And they were allegedly investigated. Only one soldier was prosecuted, and that was for stealing a credit card. So then you remember a month or two ago, there was that terrible killing of 7 aid workers, 7 UN aid workers. The world was shocked. It was clearly manslaughter by gross negligence. The 2 commanders who were responsible for giving the order were allowed to retire without any sort of criminal investigation. So I think that in reality, Israel does not prosecute its own people and would not investigate. Should it be given time to take steps that we all know as a matter of practice it would not take to prosecute its own prime minister? That may be an issue that is more of criticism in theory than a criticism in practice, because in practice it's impossible to think of Israel prosecuting its own at that level. So they are 2 criticisms. One, I think, justified, but really going to tactics and strategy. The other, I don't think, is made out as a matter of reality. I think there was justice, and certainly in view of the deterrent possibilities, the sooner a prosecution or an investigation is announced, the better. So what is in store? There will be a hearing with 3 judges deciding whether the prosecutor's evidence is sufficient to justify the continuation of the prosecution of Netanyahu and Gallant. There was an attempt, I think a benighted attempt, by the United Kingdom of all countries to stop the investigation in its tracks by arguing that there was a 1995 agreement, the Oslo Accords, because it was a conference held by Norwegian negotiators in 1993 to 1995, which part of the accords set down the principle that Gaza, in thanks for being given a degree of independence, would not prosecute Israeli nationals. Now, this was a kind of quid pro quo in an agreement which was loosely agreed 30 years ago and which has not been respected by either side. In my article, I say it's a dead letter and has been ever since the Camp David meeting organized by Clinton in 2000 got nowhere. And of course, it's been breached by Israel, most particularly in encouraging illegal settlements. But there it is, Britain with no purpose at all, no right other than they technically, as a member of the ICC, are entitled to make a I suppose it's jurisdictional challenge to these proceedings going ahead on the basis that it's precluded by the 1995 Oslo Accords. Well, my argument is A, that's they're a dead letter, and it's preposterous to suggest they can bind the ICC. But particularly as they were negotiated as a provisional attempt at a 2-state solution, long before established, and in particular because the ICC on an international law level. It's not bound by local laws or amnesties, or and that's going to be important in Putin's case. It's simply not bound by local laws. There are a lot of cases to that effect, including my own court in Sierra Leone. We kept saying that we're quite different from any limitations that exist under local law. And this idea that Britain has sketched in outline that the prosecutor, that the Palestinians have delegated the prosecution of Netanyahu to the ICC is simply ridiculous. The ICC prosecutor is not a delegate of Palestine. He is operating under international law with fully fledged independence. So I'm not, Britain may, as a result of the elections, Britain's new government may pull that unnecessary and unhelpful intervention and leave it to Mr. Netanyahu himself to make it, or to some other state. So we wait to see. Britain has been given up till the 26th of this month to decide whether it's going to persist with this intervention. So, assuming for the moment that that goes away, although Netanyahu may raise it subsequently, we have the 2 charges that he faces. The charges against the Hamas leaders, I think if the facts are established, then I can't see any defense. The taking of hostages is a grave crime under the Geneva Conventions and the Article 8 of the ICC Charter, and the killing of civilians, 1,000 civilians, is certainly a war crime. So, what of the charges against Netanyahu and Gallant? Using starvation as a method of war has long been condemned and is there in black and white in Article 8 of the Rome Statute. It requires a high level of proof beyond reasonable doubt. And that is where the allegation may well founder, because it's going to need to show that Netanyahu and Gallant deliberately directed or had at least command responsibility for the denial of food and medicine and water and electricity to the civilians of Gaza. I haven't looked at the evidence, but the prosecutor claims that he has eyewitness evidence, insider evidence, perhaps minutes of the Israeli government, I don't know. But he has submitted his evidence to an expert committee of a number of international law experts and several former UN judges, including Ted Merrin, whose name is most distinguished, and they've all endorsed his decision to take the action. Well, there is no doubt that starvation as a tactic of war has been condemned and is a crime, and that will depend on the evidence the prosecutor brings forward. That he has such evidence or claims to have such evidence is a pretty good reason for allowing this to go ahead. It's a horrific crime since ancient times, and it is a matter that certainly the world must take seriously as a crime against humanity. So there is an importance in prosecuting it. Now is the indiscriminate, which, looking at Ukraine, looking at other countries, looking at the future of drone warfare, does, reading accounts of the Blitz, does seem to me to be a most horrific crime, which should be explicitly condemned. There should be a law against it, and there isn't. Why not? Why do you never find indiscriminate bombing in Article 8, enumerating every possible war crime? Well, it was there, I think, in the 1924, just when bombs were thrown over the side of Sopwith camels. And the Hague rules of aerial warfare, when they were first put together, banned the indiscriminate bombing of civilian areas. But it disappeared. Why? I'll tell you why. Because of Britain and America. Because of British embarrassment at the bombing of Dresden. If you've read Slaughterhouse-5, Kurt Vonnegut was actually there as an American POW. It was rightly regarded as horrific. The guy who organized it, Bomber Harris, backs have been turned on him ever since, no memorials. Britain has been incredibly embarrassed by its deliberate targeting of civilians at Dresden in 1944. But the deaths of civilians were, dare I say, only 25,000, less by 10,000 than the deaths of civilians in Gaza today. So you've got put Dresden in perspective, but it has been a reluctance of Britain to countenance a law specifically against indiscriminate bombing. As for the Americans, the firebombing of Tokyo incinerated 100,000 people. And by Curtis LeMay, the leader of the Air Force, whose advice to Kennedy in relation to the Cuban Missile Crisis was simply to bomb Cuba. So that too has been an embarrassment, and that's why Britain, sometimes put up to it by America, has opposed any clearer war crime than attacking civilians, no mention of bombing them. And there is a defense, there's certainly a defense of proportionality. If you say, as no doubt Netanyahu, if he goes to trial, will say that civilians are merely collateral damage for an important military objective. But I don't think damage can be called collateral when it results from a direct hit. Anyway, that's for his possible defense. But I think it's important that there be a trial. There should have been a trial of NATO back when it bombed in 2003. I think it bombed Belgrade. It bombed bridges with civilians on them. It bombed a Chinese embassy. It bombed a television station, killing 16 journalists. That seemed to me to be at least raise the question of indiscriminate bombing, and it was funked by the then prosecutor, who's a friend of mine, but I don't think he thought at the beginning that the ICC could begin its work with an indictment of NATO. But it should have, in theory, and there it is. We never sorted out what actually the war crime is of bombing civilians and what defenses were available. He did put together an expert panel, as we saw the present prosecutor did in relation to Netanyahu, and they were named, and they included a couple of very important judges. But the panel that was put together to approve or not the arrest warrant was not named, which was probably a good thing for their subsequent reputation, because their report was really unacceptable. However, there is a reason why it would be a good thing for the Netanyahu trial in relation to the indiscriminate bombing, which has caused more deaths than Dresden, should go ahead so that the court can develop the law relating to the indiscriminate bombing of cities and the deaths of civilians. I think I've spoken for long enough, and so that's a bird's eye view of the issues that we face now in relation to the indictment of Israeli politicians as well as of the Hamas leaders. And my own real criticism is that they came at the same time.
Well, I mean, there's a lot to unpack there, I think. And just in the spirit of open dialogue, please, if any of the panelists ever want to respond at any moment, please feel free to. And also out to the room, if you have questions, feel free at any point just to put your hands up and direct questions to us. So it's not just me specifically turning to each individual and saying, what do you think about this? Despite that, I will put out something of an open question to the panel, to whoever wants it. I think what I find very interesting in that is this notion of, okay, this is an ongoing dispute. And to what extent is the ICC's role in this moment, or generally in relation to any dispute, supposed to be reactive, naturally, okay, we're trying the crime of something that's just occurred, versus proactive, as in something is currently occurring and we need to stop it while it's working. Obviously, it's all framed within a reactive sense. Okay, you've committed a crime and we're going to stop it, but of course, we can't ignore the context that the crimes are still going, and especially the relationship between that and the evidence that would be required. And obviously, when there's an ongoing conflict, this fundamentally shifts our ability to go in there, find evidence, and be able to try it properly. Some would argue that it's going to be much easier to try the crime properly once there's the proper ability to send investigators in to find evidence after the fact. So, when the crime is charged during the conflict, naturally, you're essentially deciding that you're not going to have access to that same level of evidence, ideally, to try to affect things faster. And I wonder if
I think picking up on that is picking up on what Jeffrey, might I say, so eloquently outlined for us a moment ago, that in my view, one of the essential features here is deterrence. And my instinctive response to your question is the ICC, we, humanity, call it what you will, should not be waiting for more alleged atrocities to occur simply to gather evidence. If the court are of the view that there's enough evidence now to bring these allegations, then it is important, in my view, that those allegations are brought and properly litigated, if only, and importantly, for the deterrent effect that potentially would have, is my instinctive approach to that.
Do you think that that's ultimately something of a trade-off, therefore? Because, of course, theoretically, after the fact, you might find evidence of all kinds of other things, or perhaps you find evidence that the initial crimes were not as clearly illustrated as possible, or certain things led you a certain way?
Well, simply applying general criminal process and procedure to this, and I would presume it would apply equally internationally as it does domestically. If fresh evidence arises, then there's always an opportunity, should it be appropriate, although it might not be considered appropriate, depending on what happened in any potential first trial. If fresh evidence arises of such a substantial nature that it requires prosecution, again, A, for the deterrent effect, and B, to potentially that what conduct is condemned, then there's nothing stopping, in my view, another potential process. But the bottom line for me would be that deterrent element. You can't just sit back, in my view, and see these issues arising and these allegations mounting, and simply sit back and say, well, let's just keep the evidence mounting. One should do what one can. And I say in passing, it's not just a lawyer thing, it's a political thing as well. It ultimately, this is going to be stopped politically. But obviously the law is an important part to play, and it's what Karim said in the film we saw yesterday, that the law has a role to play, and to use a rather inelegant expression, needs to step up to the plate. There's the debate to be had, and maybe we'll have it later, as to whether this is an important moment for the ICC as well, because there is criticism of the court, and I'm big supporter of the court. I don't want you to see my comments in any way other than supportive, but there is criticism of the court, that it is, and it's criticism, I'm not necessarily adopting it, but let's get it out there, that it is potentially selective in the cases it pursues. The answer to that, of course, is it's not their decision to be selective, it's the remit under which they operate. But nonetheless, there is that, and if you talk to people who are not lawyers out and about, this is the first thing they'll say to you. Informed listeners and readers of work of the ICC who are part of democratic society, not necessarily lawyers, will say to you in at least 50% of conversations that you have, well, there's only a certain category of people that seem to be, or states that seem to be prosecuted. Well, that misconception, if it is a misconception, needs to be dealt with. And one of the ways of dealing with it is in this instance to show that no person is beyond, within the Rome Statute guidelines, I might say. Some people are, but given that, no state or individual should be beyond needing to respond to proper allegations made. And I'll just throw one last question out without answering it. The debate also is whether the ICC should be prosecuting individuals or states. And that may be a discussion we can have as well about whether I think it is appropriate, in my view, for individuals to be potentially asked to explain themselves. But there is an argument out there, a legitimate argument on the other side of it, that the ICC should be focusing on states rather than individuals. I'm interested in Jeffrey's response to that from his experience. But hopefully that gives you a roundabout view of where I stand on this. But your question, which I haven't forgotten, is don't wait, deterrence.
To that point, though, and just to push back, because it's my role as the moderator, so I'm just be the charming moderator and try to find dissent if I can. Would you say, in one sense, you've said there, absolutely, it's the role of the court is to be, that these are political decisions. And then on the other hand, you've said, well, no, it's this common criticism is that the court is too selective in what they choose, and actually they're just working within the remit. So to what extent, and of course, Jeffrey's just said before that there should have been trials for the NATO bombings, but that wouldn't have been a good way to kind of come out the door and immediately try NATO. So in a sense, we're kind of saying that the ICC is unfairly criticized for being selective and political, but in another sense, I'm hearing that it's actually quite important that there are to create political decisions about who you're choosing, when you're making that decision, and how you're making it.
But political decisions are open for challenge, and there's also precedents the other way. For instance, when dealing with the development of Article 3, the prohibition of torture, inhuman and degrading treatment, I was only having this discussion as we were walking away last night, that you may be surprised, maybe not the lawyers in the room, that the first guideline case on what is torture was Cyprus against the UK. Now, it could have been said there, for instance, it's not particularly politic. I know it's not the ICC, but it's an analogy. It might have been said there, it's not particularly politic to have the guidelines as to the 7 or is it the 5 techniques of torture. I always get that mixed up. But the various techniques of torture should be isolated by a case for the first time brought against the United Kingdom. It's not good optics, as they say. It was done. I know it makes the decision, and we could argue whether the right decision politically not to prosecute NATO. It was the wrong decision, but there it is. That's a decision that has been made. But politics is at the behest of the person or the individual or the controlling state. And I would simply add this on the end of that answer. This is a very important moment for the new Labour government. It is one of the early decisions they're going to have to make by the 26th of July. I understand that other states that weren't going through a general election were required to respond by yesterday, unless that's been extended. So I'd be interested to know what other states who haven't had a distraction of a general election have decided on the arrest warrant issue. If anyone knows the answer to that question or can find it out, I'd be fascinated to hear it, if indeed that deadline was adhered to. But it is an important moment for our new government. This decision will be watched very carefully by a number of constituencies with a small c. And whilst a decision like this should be made sagely and in accordance with the law and with as much wisdom as possible from those that introduce it to the government, they need to get this one right. It's an early test.
Silvana, you've had a lot of experience with a lot of the issues that we're talking about. I would love to hear your thoughts.
Something on the criticisms that everyone is using the court proceedings knows very well that the criticism also used to oppose a decision are not likely by one or another. So the criticism is that it's not the problem. The problem is that this criticism, in this case, And you know that the warrants of arrest is issued by the pre-judge, or by the judge, not by the prosecutor. So after a very strict legal review and examination of evidence and insights. But I think that this point, the criticism, especially the criticism by the very influential authorities of powerful state, is to warn the states around the world to not enforce future warrants of arrest, because this is the problem. The weakness of the system, ICC system, is this. The enforcement depending on the ability to get from states the cooperation. So this is very, very difficult stage. So if the warrant of arrest is not enforced, of course, the procedure cannot go forward. And what happened in this case, it was said very well, and this is of that, the death end. But instead of death end, I would say that one of the elements that the pre-trial chamber has to evaluate in the judge in the application of the prosecutor on the warrants of arrest is the risk that the conduct which constitute the charges can continue. If it's the risk that this continues an element satisfying the judges to issue warrant of arrest. And another important element is the risk that the evidence can be destroyed. And so, and therefore, justice is not possible without evidence. So this is the huge problem that the ICC is facing, not the criticism. The criticism, I think that ICC is strong enough, is mature enough to resist or not to react in a not appropriate way to criticism. One way, legal way, would be, in my view, to try to investigate on complicity, because the criticizing very strongly the decision of the prosecutor to apply for warrant of arrest or against the warrants of arrest themselves could be a form of complicity. So I would, in perspective, see any charge for complicity against the authorities of states who are doing this criticism. But it's too late for that, probably. But what I would underline that the charges that the prosecutor, SEC prosecutor, has so far formulated against Hamas leaders and the Israeli leaders are very, limited and narrow. If you see the report of Navi Pillay Inquiry Commission, in spite of the difficult referred on the how to investigate the complicated situation and facing also the obstruction of Israel to enter into interview witnesses. So in spite of these difficulties in this report, we have elements, we have evidence information to be verified by the SEC, of course, of very, very serious gross violation of international humanitarian law, but also of international human rights law, which includes also the violation of convention, prevention and punishment of genocide. The genocide, which is very, very sensitive issue for Israel and allies. So this is open, it's an ongoing investigation. And as the president said to the young students in the Hague last June, what court proceedings, so they say, more high is the profile of the indictments, more high is the criticism and the attempt to instrumentalize the court politically. And this, the court is not, it is, I repeat, enough mature, enough strong to not consider this criticism. But the problem will be the approach, the position that states, also states parts, will adopt when the warrants of arrest will be issued. Because I, in my experience, and according to my experience, and reading this information and the evidences that we know, the latter we don't know negotiate directly, but they are very strong evidence for the crimes charged. So here is the point that the status party should now, very at the early stage, and we cannot be satisfied by the ASP presidency statements in support of the ICC and for the independence of the ICC. These are words. So we have to encourage the ASP to take action, to establish measures which, I don't know, sanction or other measures which discourage states party to not comply with their mandatory obligation to enforce the warrants and fines. Without that, we cannot talk about justice. Will be just an abstract exercise. So it will be done. A speech has to take its responsibility because it's the assembly of state part has this responsibility to support not just by the wording, but by action, by facts, the war cases. And in Palestine situation, there is a special unfair situation because we know that even the fact that Palestine is recognized as state by status parties because it's a member state of the ICC, is recognized as state by the ICJ because it's that, but it's not. And global level, political level, is not yet recognized as such. So it is very unfair, and even more unfair is the fact that we talk about occupied territories of Palestine, where the full control is on the hands of the perpetrators of the crimes we are dealing with. Very serious, and we say for now the prosecutor, ICC prosecutor, has permitted these charges for crimes and crimes against humanity. But the investigation is ongoing, it's current, so other charges could be, or charges can be withdrawn. So we will see, but it's just starting proceedings. I hope that the state parts will act according to their power responsibilities and try to obtain ways are made in the Kampala. There was the discussion of the non-enforcement of the decision of PCC, which brings to the the authority and the role of this important institution. And the decision was that states should cooperate each other, should help each other in order to make it possible when in a state is not possible because the national judicial mechanisms are not resolved. We see it's not the good one, it's not enough. So we need the concrete action. And on the side of support, what we are now doing, this debate, this discussion is an important support. Support not for the ICC, not for the prosecutor, not for the judges. It's support for justice, which is a key component of rule of law. Rule of law concerns all of us. If we will change the legal order, the legal mondial order, and we abandon the rule of law, what happens? So this is the issue. We are trying with this debate to reiterate the importance of the rule of law and justice, independent justice key of the rule of law. So this is the point. Legally, the proceeding is very long, and this is also a matter the SP should consider. So we have at first stage, we have a preliminary examination which includes the exam of the jurisdiction of the other matters. Then, when the prosecutors collect evidence, information, and will decide if to open or not to open an investigation, a formal investigation. This takes time. Investigation on ongoing conflicts per se very difficult. The results arrive very late, and this is a big problem. Especially if there is no sufficient cooperation of states and organizations. And at the other end is the the judges, as I said, will review the application based on the evidences that the prosecutor has submitted, based on the legal analysis, very strict legal analysis. And among the elements, and this I did because it's very important, the two elements are very important, is to stop the continuation is necessary. The warrants of arrest is necessary to stop the continuation of crime or charged crime or crime of related connected nature, or to obstruct, to avoid the destruction of evidences. These two elements, which are also elements that you can find at national level, when a prosecutor at national level has to apply and the judge they have to decide on the warrants of arrest. These two elements are key. So why we cannot just summon an accused act to achieve, and why we need to arrest him forever? Because also we have these two important elements which are essential for justice. So these are, I would extend my saying, because the item we put to us, to our panelists, the legal, no? We put aside possible emotion, which are also normal these days. But if we put aside our emotions and we just consider the legal issue, so if we consider the founding treaty is a source of international law, the court is applying the international law, the treaty should be known, should be principles recognized universally in customary law, and even principle or other sources which are relevant coming from national system, national judicial system. It's a pure legal system. So politics should not interfere. I think the risk is that the states who will be called to enforce the decision, and this is the great point of the ICC, it's not our authority, enforcement authority, depending on the states' cooperation. So we can find a solution. Nothing is perfect. No, but everything can be improved. So states parties are in their end the responsibility to make possible that this enforcement will be really realized. So this I just stop there, but probably I have another question to intervene, but this is.
Yeah. I mean, what do you think, Dina, about? I mean, I know you've done a lot of research on this.
Yeah, I want to the legal element, which is obviously inherent in this case, but one of the criticism, as Geoffrey Robertson also introduced, is about whether the ICC breached the principle of complementarity by issuing arrest warrants. The principle of complementarity is one of the key provisions of the ICC system. So to that question, the brief answer is no, but why? So the ICC is bound by its own statute, right? We know it's the Rome Statute. Article 17 and Article 19 of the Rome Statute regulates the inadmissibility of a case based on the provision in Article 17. So according to Article 19 of the Rome Statute, the court's jurisdiction over a case may be challenged if there is a national investigation or prosecution over the same alleged criminals and same alleged crimes at the ICC. If that precondition exists, then the court looks into another point, which is as to whether the state in question is or was willing or able to genuinely conduct such proceedings. Now, looking in our case, we can see that there is no prosecution or investigation ongoing over those crimes, and we don't see any prospect either. So this precondition is met. So we don't even need to go whether the state here, Israel or the state of Palestine, is willing or able to genuinely conduct such proceedings. So then we go to the second important provision, which is Article 18 of the Rome Statute, which sets up a mechanism for the prosecutor to notify national authorities of the prospect of the Office of Prosecution opening of an investigation, and hence giving states the opportunity to initiate proceedings of their own. So now that was one of those highly contentious parts. Some scholars disagreed with the prosecutors that prosecutor Karim Khan, that he gave enough time or opportunity to the state of Israel to open an investigation. Now, it might look on the surface that this is the case, but there are two issues to look into. First, this shouldn't come as a surprise to anyone that the prosecutor Karim Khan issued an arrest warrant, because he has been warning, first of all, since the beginning of these attacks and the siege of Gaza, that he has been following, his office has been following the situation in Gaza and the dire humanitarian situation. So there was sort of warning against Israel that there is going to be an investigation. Second, again, this didn't come out of nowhere, this investigation, and this is related to also the 2020 preliminary examination report issued by then prosecutor Fatou Bensouda about the situation in Palestine. So Bensouda back then relied upon to open that investigation to provide significant information relating to the prosecutor's intended investigation back in 2021. And back then, a notification was actually sent. So the legal question here is that if a new notification was necessary, formal new notification was necessary, or could it be considered as the continuity of then prosecutor Fatou Bensouda's investigation? So when we look at the precedents of the ICC pretrial chambers decisions and the appeals chambers decision, there should be a sufficient link between the previous investigation or the notification and the current investigation or the current situation. So can we see that sufficient link? One can argue, which I'm on that side, is yes, there's a sufficient link between the alleged criminals, because the parties haven't changed since 2021. We are talking on the one hand Hamas, and on the other hand the Israeli leaders. And the context of the crimes are similar, although in the first investigation there was no starvation under the crimes against humanity, but the substantial grounds were there. It was more about illegal settlements. But also, when we look at 2018 report of the United Nations, we see that back in time, in 2018, there was also warning that the to serious starvation, or there was a dire need of humanitarian intervention for food, because there has been blockage of food for a very long time. So I would argue that there's a sufficient link between the previous investigation and this investigation. Hence, there was no need for official, at least, notification under Article 18. And according to Prosecutor Khan, made it according to the Rome Statute, the complementarity principle was not breached because there was no investigation or no prospect of investigation, and notification was sent in earlier investigation, but there was also warning of Karim Khan about the prospect of investigation. So that's what I wanted to talk about, the complementarity part. But I also want to add about the UK's intervention, which I found also little merits in that intervention. So when a state becomes a party to the Rome Statute, it does not delegate its own criminal jurisdiction to the ICC. It simply accepts the criminal jurisdiction of the ICC. So in that case, it is not the state of Palestine, which is a party to the Rome Statute. It's not the state of Palestine that will exercise its criminal jurisdiction, but it's the ICC that will exercise its criminal jurisdiction. So from this perspective, I think the objection of the UK based on Oslo records has little merits, and I expect the pretrial chambers to to reject that on the basis of criminal jurisdiction of the Palestine. I can only see in the future one possible scenario whereby the state of Palestine will be asked to surrender certain the current prime minister of Israel and the defense minister. If it's, the state will be able to do so, which is highly unlikely, then it might violate its own internal laws or agreements of the Oslo Accords, but then it's still not subjecting these individuals, the prime minister and defense minister, its own criminal jurisdiction. It will be only to help the ICC to exercise its criminal jurisdiction. And perhaps to John's point, the last point about whether a state should be held responsible under the Rome Statute. Well, that would go against, I think, the rationale of the ICC, the Rome Statute, which is based on individual criminal responsibility. So it can be only individuals that can be held responsible before the ICC. But that would be interesting to see that almost sort of conflict between the International Court of Justice and the ICC, because as we know at this point that there's concurrent proceedings before the ICJ, but it is only the states that can be taken before the ICJ, not the individuals. And obviously it has nothing to do with the crimes against humanity. It is about the prevention and punishment of the Genocide Convention. So I might ask, do you think this is not sufficient for the ICJ to look into more states' actions under the Genocide Convention, or do you think that should be still considered by the ICC?
I mean, the answer you've given, I wasn't propounding a necessary argument one way or the other. I was simply putting the question out there. My only observation on whether a state should be prosecuted is that it may bring in more potential evidence rather than that applied to the individual, and may assist when it comes to accountability. I'm just throwing that out there. I'm not necessarily saying it is right or wrong, save that there is a debate going on about whether the ICC should apply itself and change its rules if necessary to encompass a state, and whether by doing so it would enhance accountability, but it's only an argument.
It's a debate that's foreclosed for many years by Justice Jackson's brilliant opening at Nuremberg, when he said, in effect, that crimes are committed by men, not by artificial entities like states. And that was the whole basis of Nuremberg. And it left out corporate responsibility and it left out state responsibility. But the argument against that is now perhaps and in accepting state complaints against states. I mean, dog never eats dog in the ICJ until recently, was it Ghana or Gambia took up Myanmar, and South Africa took up Israel. And we're now seeing a greater interest in a number of ICJ judges in becoming, as it were, a World Human Rights Court. So states are at last being held to account, if only under the Genocide Convention, because it's the only passage to the ICJ that's accessible. So the debate has perhaps been changed a little by the ICJ approach.
Watch this space.
Yeah.
I want to open it out to the floor. I think if anybody has any questions, we're coming up to the final, I guess, 15 minutes or so of it. So if you want to get in here, this would be the time. Yes, please.
Well, I found this very informational and interesting, and I thank all the panelists for giving us their time in this way. I have to admit, however, that my takeaway, certainly at the moment, is that, and I've been involved and interested in the ICC activities since the idea of it was put forward. And, my impression is completely in accord with our first speaker, that what we see in the ICC is primarily victor's justice. And what we're seeing with the Israel and Palestine arrest warrant is the prospect that the prosecution of those entities in the ICC is perhaps aspirational and certainly unattainable. We are certain, are we not, that Palestine is not going to surrender its Hamas leaders because Palestine's leaders are Hamas. And we're quite confident that Israel isn't going to surrender Netanyahu or his superior or his subordinates at all. I was a little bit concerned that the notion of command responsibility has been brushed aside, simply looking at the fact that Netanyahu happens to be the leader of his country doesn't accord him any protection unless he's taken the reasonable and necessary steps to prevent crimes. That's prospective. So when and if we see a memo from Netanyahu to his subordinates that says, please take all necessary and preventive, necessary and reasonable measures to prevent starvation, that's in a prospective manner, and he is entitled to rely on his subordinates to carry that out. The way that Article 28 is written provides in the alternative. It's not an and or, it's or. So Netanyahu, having written that memo to his subordinates, provides him, and I'm speaking in the abstract, of course, provides him with cover under Article 28 to avoid command responsibility and doesn't require him to prosecute anybody, which, as we've heard, is an extremely unlikely event in any case. I think that I happen to be a defense attorney, and I think that the command responsibility exit lane for leaders is big enough to drive a truck through. And the likelihood of prosecuting either Israel or Palestine ultimately is merely aspirational. The notion of holding states accountable is a remedy with no consequence. Why, if Israel or Palestine is held accountable, we know that their response will be, so what? And so I wear explosive colors when they're elected. And if they violate the rules, off come their heads. It might be more effective and certainly aspirational as well.
That could be extended to lawyers if they lose a case, so I'd be worried about about mission creep on that.
So you want to respond to that, Jeffrey? Perhaps I'm sure you have something to say in response to that.
I don't know. Do you want to take any other comments, and we can come back to
Absolutely. Does anyone else in the room have anything to add to that, or something entirely other that we can happily put together with? I think that's quite a firm provocation that I'm sure we can talk about comfortably. I think we're just going to sit with that one, Jeffrey, if you want to.
Well, up to a point, of course, it's correct. The ICC has this power vacuum, as does any decision of the ICJ, and that is something that we contend with. And the ICC, in its first 20 years, has basically dealt with Congo warlords and no one else. And this is a great test. The test, what we have to hold on to, is the fact that the existence of the ICC does allow discussion and realization of international standards, basic standards of treatment of others in war and in peace, for that matter. The International Criminal Court by issuing arrest warrants, by issuing indictments, and so forth, causes some discomfort. Putin is not able to go where he wants to. He wanted to go to South Africa and couldn't, and now has to console himself with the leader of North Korea. And so it does have those symbolic consequences. May the symbolism go further. I've advocated in my book, The Trial of Vladimir Putin, that the only way international law can be vindicated in relation to great criminals who possess nuclear weapons is by the trial in absentia, which this organization has done something to promote in terms of mock trials. But mock trials are inevitably mock. If they are given official status, as the Lebanon tribunal was, as a trial in absentia. Anglo-American lawyers hate trials in absentia. They don't understand why they are acceptable in Europe or indeed in Ukraine. But there it is. In a case like aggression against Putin, what is the difficulty with a trial in absentia of the man? Because the facts are clear. We've got newsreels of the tanks rolling towards Kiev. There is no difficulty in establishing the facts. And if there is any defense, if we need to hear from Putin, which I don't think is a matter of law we do, but if we do, we've got his long 5,000-page essay on why Ukraine is part of Russia, and we've got his interview with Tucker Carlson and other such evidence. But that's something that I think is the next step. The ICC bans trials in absentia. Maybe if it's to have the importance that it should have, and at least declaring who's a criminal and who isn't, and being able to brand individuals as indicted war criminals, so they can't travel very far or to very interesting places, then it's worth, I think, going ahead. Others may disagree.
Let me use the unlikely analogy with me on this one in this country, which I was involved with, and the argument there was said, well, what's the point, because people will carry on hunting and the whole process will continue, and those that want to hunt will just find ways to hunt. And the argument we put forward back on that was that it's important for society to put a marker down as to what is accepted, what is criminal, and what is not criminal. I use the analogy often in debate on the issue. The Theft Act 1968 developed criminalisation of burglary. It didn't stop burgling or theft, but it's set down standards. So forget the roundabout analogy for a moment. I've got there in the end. The point I'm making on this is that sometimes the process is necessary to set down standards. In the example I gave you on hunting, it was domestic standards on a particular issue. Here, it's standards on an international basis on what is acceptable or not acceptable during conduct, during the process of war. Again, using a domestic analogy, perhaps, when the Crown Prosecution Service in the United Kingdom consider whether to prosecute a case. I think we had this discussion last night over dinner. The two parameters they assess as to whether to prosecute is, one, is there broadly a 50-50 chance of success? And secondly, and importantly for this debate, is it in the public interest for a prosecution to be brought? It's not, will a person necessarily abide by a conviction? Will a person even turn up for trial? That's not a criteria put into place. It's the criteria of chance of success, reasonable chance of success, and importantly, is it in the public interest? So secondly, on that basis, I would argue that if the evidence is there to potentially substantiate an allegation, it would be in the public interest, particularly in the context of what we're discussing, for the matter to be brought or attempted to be brought to court. What the potential defendant does after that is a matter for him or her. But the process and the approach is important. What else? Trials in absentia. Another debate to be had. There's mixed opinion, for instance, on people's tribunals. I did promise someone I'd bring in people's tribunals into this one, by crook. But there is an analogy with people's tribunals, of which I am a supporter of, and I was a chief prosecutor at the Iran tribunal, as I indicated last night to those of you were at dinner. That was the Peace Palace provided the venue. One of the important aspects of the Iran tribunal was that it brought together evidence, live oral evidence and written evidence gathered over a period of 2 years by organizations including Amnesty International, which now and still presents a body of evidence about events that took place in Iran in the late 70s, early 80s, which is there to be used as a resource either legally, journalistically, or academically, which again, from the perspective of a people's tribunal, is another example of how trials in absentia, whilst not particularly producing the person in the dock, as it were, or indeed a person, if they're acquitted, so be it, but if they're convicted, receiving society's condemnation. But the evidence gathering process, gathering evidence, for instance, in the Iran tribunal, I can speak to personally, from victims that were presenting themselves and giving evidence as to allegations of mistreatment back in the 70s. This material now is obtained. These people could be dead now. They die in the future. We could lose contact with them. But at least the tribunal, the trial in absentia, if you will, allowed evidence to be gathered, articulated, given on oath, and then available as a resource for the future. So again, an argument for it. But I do understand the black letter approach that you're presenting to us, and I get that. But there's something more, in my view, than the practicality of the individual accepting potential condemnation. It's important for society and the wider world community to, in the way as I started hunting, and that was a statement of fact and a statement of what society accepted. Similar in other issues as well.
I am an AI scholar, so I'm very excited to talk about the changing nature of evidence in use of these trials and how we're going to have to deal with evidence, but we do only have 5 minutes left. So I think in the final 5 minutes, I want to put it, I guess, either to Didem or Silvana, or actually indeed our questioner, if they would like to respond to Jeffrey or John's comments. I guess we've only got 5 minutes, so whoever's the most passionate. Silvana,
just to submit some suggestions. So the non-enforcement of the decision is also a problem with exigent, not reacting. Yeah, provisional measures, 2 orders of the force. Instead, the situation was worsening. UN resolution, even Security Council resolution, no effect. So the problem is the legal problem. And so my suggestion is, because this great gathering of experts or committed, we can say, professional committed to justice, maybe we should continue in a regular way to monitor what can happen and be proactive and maybe suggest some proposals to the ASB, because as I say, the Rome Statute can be modified, can be integrated. ASB can take measures at political, economic, or other levels, so it can be proactive. We can reflect more on this issue of non-enforcement, because it's, I have a particular concern. I know what it means when we presented the indictment against al-Bashir, the warrant against al-Bashir, and we were defeated. So it's a very tiring and exercise, and without achieving the results. And I also visited the affected communities, which was in Chad. The refugees from Sudan were in Chad, and they demanded very strongly justice. So they criticized the ICC. Why we are not efficient and effective? So this is the main problem of the ICC and our ICJ too. So something can be changed. At international level, we need an enforcement authority. We need something that ensures the enforcement, the dynamic enforcement of the decision, especially important decision like the provisional measures of the ICJ in case of the South Africa case against Israel, or Ukraine against the Russian Federation, and ICJ, especially the ones passed. So right absence is, I think, out of discussion, because we spend a lot of humans, and also in Rome, I remember at the diplomatic conference, and the common law culture did prevail. So it seems untouchable this point. So the appearance, the presence of the accused should be tried. So maybe we leave this, but we can proactively think about. As lawyers, I think that we are very keen to do that. What can be done today? This very, we are failing. If you understand the common opinion, say why you are spending too much money for the ICJ, ICC, while their judgment, their orders are not enforced, are without effect. So this also can happen. So it's a suggestion, maybe someone you can agree or not, but I put it to you in order that we regularly can monitor the base of information we receive, what is the status of this enforcement, and to try to propose something to the Assembly of the States parts to
Thanks so much, Silvana. I think that's just about, right on the dot. So we've done very well. Unbelievably, we've made it to time. So
No doubt you're thoroughly persuaded and have changed your mind. And,
Yes.
Oh, completely.
Yes.
I know
100%.
the little I know of you, I expected that of you. Yeah.
But it was, of course, wonderful to have some debate and have some pushback here, and that's the point of being here, is have some open debate. I hope we'll have even more in about, 15 minutes? 15 minutes, I'll have a short break, and then please come back for we'll be talking about war crimes and how we're going to be able to look at this. Looking forward to it. Thanks so much to the Go for it. All right, welcome back, everybody. Panel 2 of the day of our 4 panels. So good to have everybody back. So now we're going to be talking about the evolving definition of war crimes, the borderlines of appropriate military action in Gaza, how the ICC would look at these crimes, whether there's anything fundamentally different about Gaza compared to other conflicts. Once more, it's an open discussion. In the spirit of open discussion, please put your hands up the second you have anything you want to say, and it's open discourse. Again, these are contentious issues, so hopefully we'll have a little bit of debate about what's acceptable, what isn't acceptable. Or any other questions? I know already I've had a lot of debate playing out outside this room, so hopefully we'll get some of it here now as well. So I'll introduce you to the panel. I realized I was so excited about the last panel, I forgot to introduce myself on the panel. My name is Zachary Cooper. I come from the Vrije Universiteit Amsterdam, and actually my main focus is artificial intelligence and how that's changing all kinds of aspects, but in relation to these panels, most relevantly, evidence, synthetic products, how we can tell what's real, what isn't real, how you can use synthetic products within evidence, and the changing nature of evidence in relation to new deepfake technologies. I'm very excited to welcome back from the first panel, Jeffrey Robertson, KC, who is coming here with a book. So grab The Trial of Putin if you can get it. I think that I saw a couple kicking around, so maybe
They've disappeared.
Yeah, they've disappeared.
I'll send an invoice to the.
Yeah, they've been roundly robbed already. But we have some new panelists as well. I welcome to the panel Yona Diamond, who I had the pleasure of sitting next to last night at dinner. So I know you have many opinions on all the issues that we have to speak about, but Yona's also a great expert when it comes to genocide and the crime of genocide. So I'm very excited to have you here. And over online, we have David Crane with us. We're very, very lucky to have David Crane. David's had an extremely esteemed career, I guess, not least of which being the founding chief prosecutor of the Special Court for Sierra Leone, and generally an extremely prominent figure in international law. So welcome, David. Great to have you here.
My pleasure, and it's good to see my friend Jeffrey and Yona, and my compliments to you both.
And then rounding out the panel, we're very lucky to have Tapas Baul, who was also a very esteemed legal career and a prosecutor at the International Crimes Tribunal of Bangladesh. So we have a great level of expertise on this panel. So I'm really excited to launch right into it. Maybe I'll start with you, Yona. In genocide and the crime of genocide, what do you think within Gaza? What do you see as the core challenges when they're looking at war crimes within the region? Potentially, what are these sort of universal challenges that are always going to be an issue, and maybe what are the differentiating challenges of this conflict in particular, as opposed to other challenges that you've looked at? I know you've done a lot of work in Darfur.
Yeah. Thank you so much. Thanks for having me, and thanks for moderating, Zach. So the way I fell into the genocide prevention lens is because I believe I come here with a little bit of a different background than some others with who have experienced prosecuting or I started my sort of legal career at the International Tribunal for Rwanda, but I've dealt recently more with violations of the Genocide Convention and how states can respond to various breaches. So in the context of the Uyghurs in China, in Ukraine even, and now in Sudan, I've been doing a lot of work on looking at possible accountability routes under public international law to complement sort of criminal prosecution and justice efforts. And so the Genocide Convention is unique in that it has the prevention obligation on states, and so it imposes a different mechanisms that states can possibly employ rather than prosecutions to stop violence or respond and take countermeasures. And so until there is sort of a concrete treaty like a war crimes treaty that allows for the prevention of war crimes or crimes against humanity, sort of left with the Genocide Convention as something that gives the ICJ, for instance, grounds to hear a case like this. But that's just like where I come at all of this from. But I will just say that the war crimes framework, and I'll come at this discussion more from a critical perspective of the war crimes framework, because international humanitarian law is defined by three principles: distinction, proportionality, precautions. And so whenever you hear sort of international lawyers talk about how the law might be clear, the law is very clear on this, it's actually not clear at all when it comes to these concepts, because they're inherently vague. So how can you, there's obviously going to be debates about what constitutes excessive damage, what constitutes a military objective. And so we've opened this conference with a focus on aggressive wars and how rightly at Nuremberg, was it Jackson? The judgment at Nuremberg says that, the international crime of aggression is the supreme crime, and that it contains within itself the accumulated evil of the whole. And so it's important to go back to the concepts like these that allow war to begin in the first place. And it's just good to think about whether the war crimes framework should be where all the focus is or all the resources are invested in. Because, for instance, in Ukraine, it's so obvious how, looking into over 150,000 or whatever it is now at this point, incidents of war crimes, it doesn't really make sense to conduct this many actual investigations. And it's similar when a war is going on, there's going to be this number of war crime incidents on a daily basis. And so it's important to think about alternative mechanisms as well, and not acting reactively, but also how can the international community support real truth and reconciliation efforts, supplemental accountability mechanisms to stop the flow of arms, let's say, to parties. I would just say that that's where I'm coming at this from, and but I'm excited to continue the discussion. Yeah.
David, war crimes is a core mechanism of conflict.
It's a very interesting time that we're in. I call these conflicts that we're seeing over the past 24 years now of the 21st century dirty wars, where combatants and parties to both non-international as well as international conflict largely ignore international humanitarian law. And so this is a challenge for the international community, despite the fact that we've had some major successes in Yugoslavia, Rwanda, Sierra Leone. We have a permanent international criminal court, which recently, and much to my astonishment, but also support, is that they're really showing real leadership now in leading thinking related to going after individuals who feed on their own citizens. So it's a really unsettling time, a time where we need to hang on to the rule of law and to seek where we can. And of course, I've always said that the bright red thread of modern international criminal law is politics. So, we have the ability. We have over a quarter century worth of experience. We have the appropriate jurisprudence. We have solid rules of procedure and evidence. So it's really, we have the capacity to take on any atrocity that we are faced. And we have the International Criminal Court, but also the capacity to create other types of courts and tribunals to seek justice for victims of atrocities. So we're in this tumultuous time and this moving away from, until Ukraine, of the international standards and international criminal law. For a while there, we had some real challenges as countries look to the inwardly with more nationalistic approach to international affairs. And I think, frankly, much to my surprise, we have 12 active dictators and thugs who are running countries who are committing international crimes or would like to commit international crimes. So, we're at a cusp of where do we go now? We have the challenges in Ukraine, obviously. We have the tragedy of the Israeli-Hamas conflict. We have tragedies going on still in Darfur, et cetera, et cetera. And so the international community is going to, like it did in the 1990s, going to have to return to the rule of law to seek balance in seeking justice and also for international peace and security. So the context that we're talking this morning and into the afternoon is how, in fact, does the international community want to deal with atrocities around the world? And do we deal with it at the international level, the national level, or both? So that when we're talking today, we really have to understand that the dirty little wars are really a sea anchor on a lot of the progress that we made since the 1990s related to seeking justice for victims of atrocity. But at the end of the day, we are in a political miasma of turning away from the rule of law, and we have to, again, return to it to seek another balance and seek justice for victims of atrocity.
What do you think, Jeffrey?
International humanitarian law. What a stupid name. War can never be humanitarian, and war crimes as such. Is my mic on?
I think so.
It doesn't matter here, but it might. War crimes as such need to be characterized differently from crimes against humanity. But that's a history I won't go into. War crimes are changing before our very eyes. The essential war crime we can see on television now, bombed buildings in hospitals, in children's playgrounds, being bombed in Ukraine, being bombed in Gaza. We are experiencing some interesting legal developments at the moment. The crime that has access to a court because the International Court of Justice can decide issues relating to the genocide against Myanmar, and then South Africa brought an action against Israel. And so we are questioning whether the Israeli attacks on Gaza amount to genocide when they have already killed more than were killed at Dresden by the wicked British bombing of civilians, which cost 25,000 lives. Well, we're up to 37,000, I think, in Gaza at the moment. But that's a question for the ICJ, which they'll answer in a year or so. I was brought up to believe that genocide was the intention to destroy a race or religion. And so the intention to destroy Hamas was politicide, if you like, which was not a crime. But that distinction is being blurred, and the ICJ may come up with a new definition of genocide. But certainly there are many people in the world who would want it to cover the destruction, in part at least, of the Palestinians. Aggression is a crime that has recently been defined. It was prosecuted at Nuremberg as a crime against the peace, And then it really went into cold storage because the UN sent it to this committee and that, and eventually it got to the ICC, which finally at Kampala in 2010 got around to defining it. A pretty simple definition: invading a member state without the self-defense, and on a scale of gravity that amounted to a serious breach of the UN Article 2.4, which clearly the invasion of Ukraine does, and Putin is as guilty as hell of that international crime. Yet, because the man has nuclear weapons at his back, cannot be prosecuted, although Karim Khan has made a first stab at doing so by indicting him for kidnapping, in effect, some 20,000 Ukrainian children, and he's got evidence which is unassailable because it's on television, where Putin congratulated himself and his commissar, who's also been indicted for taking this so-called humanitarian action, which was in fact obviously a breach of the Geneva Conventions. So that we have a law against aggression, fine, but only 45 states have signed up to the ICC section which allows them to be prosecuted. And they, of course, are states which would never, in reality, commit the crime. Those who have, in the case of Russia, and will, possibly in the case of China, will never sign up to it. And then we have what television, the crime that television brings into our homes throughout the world, the bombing indiscriminately of areas of cities which are known to be inhabited. The bombing of the theater at Mariupol, which was known because it was written on the roof that there were children there. So obviously a defect. There is no crime as such, explicitly, of indiscriminate bombing of civilian residences and cities. That is being fought against by Britain and America. Britain ashamed of the bombing of Dresden, rightly so, 25,000 civilians were killed, but fewer, in fact, than are being killed by Israel today in Gaza. America, embarrassed, rightly, by the incineration of 100,000 in Tokyo, the Tokyo firebombing. So we've never had a straightforward crime, which obviously in these days of drone attacks we should have, of attacking civilian-packed areas of cities. You can, and Karim Khan has charged, indeed, Mr. Netanyahu with authorizing attacks on civilians, and it remains open question what defenses can be available on this charge. And there is one defense that of military advantage overriding the criminal element in the attacks on civilians. Well, what does that mean? There is another defense on the basis of proportionality. The killing of civilians was merely collateral damage to a legitimate military attack, and that again is unexplored. And the trial of any of Mr. Netanyahu, if it goes ahead, and there are question marks about that, will perhaps explain and expound what the particular crime is. So there are three of the important issues in an evolving international humanitarian law, a name I hate because it's got nothing to do with humanitarian. I call it war law simply, but in the sense that we see it with our own eyes when we turn on any news these days about Gaza or about Ukraine, and let alone Sudan and Myanmar and so forth. These are the issues currently facing war law.
A lot to take from that. I think I probably want to hone in on within the context of Gaza specifically, and I'm interested if the panelists think that Gaza is very different to any of the other conflicts brought up.
Well, obviously it's different because of the occupation question.
Yeah.
So
I
I don't want to get into that.
Okay. I think another way that it is perhaps different, and maybe you'll disagree, is that on the one hand, Israel is, of course, arguing that Hamas is using human shields, that they're hiding within civilian infrastructure, and that therefore when they bomb them, there is no way to do so without, disproportionate death of civilian life. On the other hand, of course, disproportionate death of civilian life would be something that we would consider more likely to prove it to be a war crime. Perhaps you, Tapas, what do you think about this distinction in the context of Gaza, and what do you think? How should the ICC begin to even look at something like that?
The first thing I want to share is that you know that there was supposed to be a mock trial organized by the court on Israel and Palestine situation, especially the Hamas situation, and then we interviewed two of the victims. And when I asked them that what is the difference between Gaza, sieges in Gaza and in other places, and what is the difference between the war that was before October 7 and the attack on October 7, they univocally said that the main thing is the purpose with which the Israel armed forces attacked on them. It was just to kill civilians. They had this plan to deny water supply, electricity supply, and medicine and food in the most places where it was required or needed. So this is actually, I would say, main difference. You see the way they have attacked in Gaza and in other places is, it seems that some of the reports say that they were taken by surprise by the Hamas attack on October 7, but the way then they retaliated, and for the duration they are now continuing, I think this is the difference. Because previously we have never seen this kind of, I would say, veracity and this kind of deepness in the attack by Israel. Before, yes, we can say that they were quite following the rules of targeting as set in the international humanitarian laws, but this time it seems that they are just targeting anything and everything. Like, we interviewed one person, he's he said that we can use his name, we have this permission. His name is Hammam Farah. He's a psychoanalyst and Christian minority. He said that anyone who is not a non-Jew population in Gaza, they were attacked. Not only Muslim, I would say, mosques, but also churches, they were attacked. 700 to 600 people were killed when they were taking shelter in those churches. So this is the difference. You see that this is not only about Muslims anymore. According to Hammam Farah, this is about anyone who is non-Jews and in those occupying places. So this is a huge difference this time, and it seems that to the Israel armed forces, there is no definition for war crime. There is no definition on limitation of targeting. they are doing anything and everything. Just as of today, I know that you all know about the statistics, but according to Save the Children report, 20,000 children were buried, trapped, and detained, and they were lost among these, along only in Gaza. I'm not talking about any place else, only Gaza. So this is, I would say, makes the difference. The numbers, the veracity of the bombardment, the attacks. Even one of the victims we interviewed, he said that he was sexually abused by the Israeli army. So men, women, children, irrespective their age or religion, if they are non-Jew and living in that place, they are getting attacked, they are getting mistreated, and a lot of children actually, and a lot of pregnant women, they are suffering from malnutrition. So I would say that these legal and ethical considerations for military operations are non-existent for Israeli army at this moment. So yeah, I hope that I could shed some light on the question you asked and the topics.
Thanks for
I
that,
will
David.
add more.
What do you think, David?
Let me make 2 points here. Let's just back up slightly. And I think that we need to make sure that our audience understands there are 4 principles in what we call the laws of armed conflict, which really govern combatants on the battlefield. You have military necessity, proportionality, discrimination, and unnecessary suffering. And the central core aspect of the laws of armed conflict is you must have a militarily necessary reason to use force and engage a target. If that's missing, you're automatically committing a war crime. I mean, this is a challenge that we're seeing both in Ukraine as well as in the Gaza conflict, is that a lot of the targeting is, there's no militarily necessary reason to do so. So the other 3 principles kind of go by the wayside because it's automatically a war crime by just having no reason to target whatever. I believe is this in the laws of armed conflict. Another aspect of the laws of armed conflict is that civilians can never be intentionally targeted. And I think that's a real challenge going on both in Ukraine as well as in other parts of the world too, including Gaza, is that civilians, particularly women and children, pay a terrible price in these armed conflicts. But a core principle, again, of the laws of armed conflict, which is a subset of international humanitarian law, is that you can never intentionally target civilians. So I think that's critical. And then another point is that in the laws of armed conflict, when you have combatants on both sides, the rule is even if one party to the conflict is not following the laws of armed conflict, does not give the other party license to do the same. So that if one is a signatory to the various protocols, conventions, what have you, to include the Geneva Conventions, you're bound by them, even though the other side is not following it. So that does not give you some kind of out by saying that the other side is not following it. So I think it's really critical that we lay down some of these 4 principles. And I'd like to make a point that Jeffrey had made, I think he alluded to. Recently, I have been thinking about what's going on in Ukraine, what's going on in Gaza, and how there is literally wanton targeting of civilian targets, wanton killing of civilians, as I've talked about. And, one of the aspects of crimes against humanity, and you find it in all of the major tribunal statutes, is at the end of that particular section, they list as an example the various types of crimes against humanity. And then at the end, they always say, and other inhumane acts, which allows a chief prosecutor or a country to consider what is going on in the combat if it doesn't quite fit in other definitional examples of crimes against humanity. You basically can create a new crime for all intents and purposes. I did that in West Africa with forced marriage in times of armed conflict, the bushwife phenomenon. that just didn't fit into sexual slavery or rape. It was more, the gravamen of that crime was more than that. And so one of the things, and I wrote an op-ed about this about 4 or 5 months ago, I've been looking at another inhumane act related to what's going on in the world today, and I call it failure to protect by mass destruction. And I think Geoffrey was talking about that in some ways, in the sense that we don't have, we have an ignoring of civilian targets and civilians, and so you have combatants just destroying, just to destroy, with no militarily necessary reason to do so. It's not quite a genocide. I don't think that they intend to destroy in whole or in part peoples, as the definition of genocide in the Genocide Act largely contemplates. But we do have mass destruction of whole societies. And so I'm proffering today a thought process, is that if it's the foreign policy or the military policy of the nation in combat to just destroy the other side because they can, that needs to be considered potentially as a crime against humanity. And so I'm proffering this for open discussion now, and as well, subsequently, is that with this mass destruction that's going on by the Russian Federation in Ukraine, by Israel's mass destruction of Gaza, that we actually consider another inhumane act. I certainly would if I was the chief prosecutor right now, to create a new crime against humanity, another inhumane act, which would be in the indictment, and other inhumane act, as we did with forced marriage in times of armed conflict in West Africa, and charge the combatants with essentially mass destruction, which is just a policy, a military and policy of just destroying the other side with no militarily necessary reason to do so. So I'll leave those points for all of us to think about and consider, but thank you.
Thanks, David. I think just on that, and just purely in my my devil's advocate position as moderator and to try to create debate, and if there is this kind of extra, additional, and create too broad a framework where, well, why even have anything specific? If we're going to say, okay, it's bad, and you said earlier, every war is going to be full of war crimes, enormous amounts of war crimes, to the point where you can't even, individually or granularly go through each one of them. Is there an issue with international law if we go, and also here are our main crimes, or what have you, but also anything else you do inhumane in the time of war, and like you said, there will always be inhumanity in the time of war. We can construct a crime for that later. What do you think of the pitfalls of that, or do you think that's a very positive thing?
Yeah, I'll stay in line with my earlier approach to encouraging us to think of ways to use the law outside of the context of prosecutions to stop conflict. Yeah, yesterday in the film, Luis Moreno Campo was talking about how the law can be used to manage conflict rather than the use of force to sort of manage these conflicts. And the problem with some of these discussions around how do we prosecute properly is that we don't look at the root causes. This, of course, did not begin on October 7th. It's not like Bibi Netanyahu and Gallant woke up one morning and said, we're going to impose, or we're going to block aid from coming in, or Hania woke up and said, I'm going to launch this attack on October 7th. There is more than 100 years of conflict between these two peoples. And when the international community thinks about accountability in the narrow terms of the perpetrators in this moment, it seems a bit nearsighted and not actually looking at the structural and real drivers of conflict. And so I'm very interested in how the ICC can speed up or complement or accelerate the efforts by Israelis and Palestinians, let's say, to come to a sort of truth and reconciliation process. How will that inform this in the future? And how could have the international community acted more preemptively, and how can lawyers, what about defense industries or other ways in which the conflict is sustained? It's not just about individuals, but there are other factors that are driving conflict today. To talk about Sudan, for instance, which is just incredibly overlooked in the media and so shamefully underreported. 10 million people displaced, 25 million people in need of humanitarian aid, an estimated 2.5 million projected to die of famine in the coming months, and ne'er a word from basically the international media on this conflict.
Or for the international organizations like the African Union or the Security Council.
Yeah, absolutely. And so, but in this conflict as well, you see external actors supplying arms. So the UAE is funding the RSF, and Egypt, Iran, Wagner Group is involved. And so when we talk about perpetrators, so it's not just the RSF leader, it's also the gold trade. It's also, we also have to think about the dynamics that drive conflict. It's also about this competition over exploiting resources in Sudan, and what are the incentive structures for outside actors, corrupt actors that are benefiting and profiting off of this. And similarly, we have to look at Israel-Gaza also with this kind of lens. And it's not only about individuals, but there's a long history behind all this. And so sanctioning the specific entities that might be involved in supplying the weapons, let's say, or making sure that countries can't trade or engage in this way. I just think there are a lot of other ways to manage conflict that are worth thinking about.
Theoretically, if you sanction a country for a judicial decision, do you think that therefore it's fundamentally different in character? Does it create more of a free-for-all, and then you're just purely in a space of geopolitics rather than having any clear international standards?
That's a great question. I mean, I think that there should be more of an impartial process for imposing sanctions. Let's say, there should be a legal process to determine when, but it should be a lower process because it's more of a civil thing than a criminal. And same with using other regional tribunals or the ICJ. There could be more litigation at that level as well. But that's a good question, yeah.
Yeah, but there's a precedent for it. There's no difficulty in finding individuals from gas companies, Zyklon B and so on, guilty in supplying to the concentration camps when they knew what use it could be put. And I think the same now goes to war monument manufacturers who supply to Israel in the knowledge that it will be used to bomb. But I want to go back to David's suggestion that we have a new war crime of mass destruction, which it seems is simply another way of putting, he would have missed this morning, but where I set out the need for a new war crime of indiscriminate bombing of populated city centers, cities, which, as I explained, had been there in the 1924 Hague Convention at a very early stage of aerial warfare, but had been dropped largely because of British embarrassment over Dresden and American embarrassment over the firebombing of Tokyo, and it wasn't picked up by the ICTY, which didn't have the gumption to prosecute NATO over the bombing of Belgrade. And so we don't know, Karim Khan has reached for a couple of crimes about attacking civilians, but one advantage of the trial of Netanyahu, whether it ends in guilty or not guilty, is to work out what the crimes that exist involve at the moment. Does he have a defense of they're hiding their Hamas fighters in hospitals, so we're entitled to destroy hospitals? This has to be decided, and it's at the moment simply not clear. Is there a defense, as there is to one charge of killing civilians, that the military advantage is clearly clear, and so the rest is collateral damage? These questions need to be worked out. There was a case earlier in Gaza where the Israeli government admitted to killing 50 members of a refugee camp in order to kill one Hamas fighter. Is that proportionate? I don't think that a war crimes judge, any more than a moral philosopher, would think so. But we've got to have some precedents. If war law is to take on a form of deterrence, which is part of the job of law, then we need to know how these defenses will work out. The difference between the Hamas arrest warrants and the arrest warrants on the Israeli ministers is that the Hamas warrants, there's no defense to kidnapping, taking hostages, and to killing civilians. But in the Israeli case, there are defenses, and whether and how they should work out is something that we really must establish. And I think that an amendment to Article 8, as suggested by David, whether it's his words or mine or someone else's, needs to cover the horror that we see on television every night of the million residences in cities.
But how clear are these lines of what's acceptable or what isn't acceptable? How much is this open season? To Yona's point, okay, you have a terrible conflict and there's an enormous amount of destruction, and how can you even go into every individual bomb that Israel's dropped and check whether that one was acceptable in terms
Well, you can't. You go into the policy.
Yes. And so, but even within that policy, let's say the policy is, okay, we only target if there's enough military combatants, but Israel is saying, yes, all of these people were military combatants, and perhaps the Palestinian side is going, no, we don't agree that there were that many military combatants.
Well, Hamas killed 400 military combatants and over 1,000 civilians. That seems to me sufficient for a prosecution. Israel, no doubt, I don't know how the prosecution will charge. No doubt he'll take a number of examples and see them as part of a pattern of a crime against humanity, systematic bombing and killing in the knowledge that children are going to be buried in large numbers and under the rubble.
So it seems to me,
If I could just intercede just real quickly, let's make sure we understand. It isn't as fuzzy as we appear to be alluding to. There are very clear-cut legal principles by which combatants in an armed conflict, be it non-international or international, have to abide by, and it's been in place in some cases for centuries, but certainly since we laid down the 4 Geneva Conventions in 1949, but we also had the Hague Rules of 1907, et cetera, et cetera. So I would humbly suggest that we be very careful as to, we call these dirty little wars just anything goes kind of approach to the law. Clearly, both sides of the conflict in the Gaza conflict, but certainly in the Russian Federation, Ukraine, they are just violating international law, period. They're ignoring it. Their armed forces are ignoring it. They're not, don't even be trained in it. So there are very specific and bright line legal principles that one must follow when one finds oneself in an armed conflict under the laws of armed conflict. So I really kind of want to make that point. Also with Yona, I think brings up an important point is that, international tribunals, even though I'm specifically talking about the practice of creating tribunals and prosecuting, that's obviously where I was coming from, but I'm a very big believer in international justice being more than just prosecuting. And we showed that in West Africa. We had a truth commission that was working with us, and I made a specific point of working with the Truth and Reconciliation Commission in Sierra Leone so that we could seek justice for the people of West Africa together. And I coined this term, truth plus justice equals sustainable peace. And so it's more than just going in and prosecuting. An international tribunal is a stability instrument, but also a way that shows the people that no one is above the law. The rule of law is more powerful than the rule of the gun. We also had our town hall program and our outreach program. We went out, I literally, this was part of my phase 3 of my 10-phase general strategy in West Africa of going out and listening to the victims tell me what happened in any particular place. And so that particular outreach program is used to bring in the people of West Africa, particularly Sierra Leone, and allow them to voice their perspectives as to what we should be doing related to seeking justice. So, Yona makes a good point related to the fact that tribunals are more than just about prosecuting, but also doing much, much more. And we showed that with the UN Special Court for Sierra Leone.
And yet I feel like, much to my excitement for the quality of the debate on this panel, that there is something of perhaps a difference of opinion in how Yona feels about it, to perhaps how some of the other panelists feel about it, in that I feel, Yona, and maybe I don't want to misrepresent your views here, but I feel you're purporting that perhaps the ICC overall is not really the best means of, interrogating a conflict like this, that ultimately this isn't the best means of going about it. Whereas I feel, and on the other hand, Jeffrey, we should be expanding the remit of ICJ or international law in general, more instruments by which we can charge.
We're actually, I think, limiting it. We want a precise crime to serve as a deterrent for a start.
And what do you think about that, John?
I'm just.
Actually, Tapas, yeah.
Now, I'll just add with the thing that it's right that we need more political willingness within the international community, because you see, there are more political leaders who are not recognizing what is happening in Gaza and in Ukraine and in Sudan as well and other places. And they are taking aid from legal loopholes. For example, now we are talking about new definitions of war crimes, or including more components like mass destruction, indiscriminate bombing, or like starvation. But the main line is that there are less political willingness day by day from world leaders whose voices matters. And also the rulers like Netanyahu or Putin or Xi Jinping, they need to understand that, yes, prosecution is not the last word, but they need to recognize what their actions are doing to the innocent people. They are in total denial. That is what is the most painful thing. They don't accept the result of their actions. So, for example, Israel is talking more and more about self-defense. But where is the ending of this principle of self-defense? Then no one is talking about that. That you can, yes, once you drive them within their territory, that's the end of it. But if you can't control your actions after driving these people within their border, capturing them, and go on this mass destruction and killing these children and women, that totally shows that their denial or lack of understanding of the result that they are doing. So I believe that we need 3 types of mechanism to address the situation. Definitely, we need a national mechanism in each and every country, and we need a regional mechanism and also international mechanism. The main problem, as Jonas said, that the lack of political willingness, which we need to address immediately. Thank you.
David, I'm interested when because you've said very eloquently that actually, it's not fuzzy, it's not this big open season about anyone can do anything and then we go and look at it at the end. That there's very clear standards about what's acceptable, very clear crimes about what's acceptable. So within the context of, let's say you're either a Hamas or an Israeli military leader, do you think it's very clear on the ground right now within the context of war, okay, when you're presented with some sort of, question of proportionality, whether it's clear on the ground right now what is acceptable or what isn't acceptable within the context of a war like this?
Well, again, you have to go down into the actual view of the combatant itself, the officers and the men within particularly the IDF, as to what their objective is for that particular combat situation. And so when they receive their operations orders, they receive the objective of what they're going to do. And within that, and we do this in the American Army and NATO in general, is that the principle of military necessity is considered and only considered. Because again, it's very clear when we train our armed forces at the NATO level, it is a war crime to just issue an order by destroying this block. So what happens here is, and this is what's really happening, and again, urban conflict is the bloodiest of conflicts, and it's terrible. But again, when the objective would be, we have intelligence to show that there, for example, as a hypothetical, that there is a Hamas communication center in this building. All right, that is a legitimate military target. But when one is now planning the military operation around taking out that particular signal headquarters, what is a proportional response to that particular military objective? And so you have to look at your tools of what kind of weapon systems do we have that can precisely communication center. But if one starts straying and considering, well, if we just take out the entire block with civilians all around, yeah, we'll certainly destroy the communication center because it's easier to do that. We have larger, more indiscriminate weapon systems, bombs, GDUs that will just take out the block. It takes out the communication center, but it also kills 500 civilians. So it violates not just the proportionality aspect of this, but also an indiscriminate attack on civilians, which is what it appears to be, is that in some ways the Israeli Defense Forces are taking the easier route in just taking out the city block as opposed to specifically targeting it. I'll give you a real world example. Back when I was legal advisor to a special operations unit in a particular part of the world, we had a very bad guy that was a legitimate military target. And we had been tracking this guy for a year. And we finally had him in the open. We had a drone on standby to put a harm missile into wherever he was to take him out as a legitimate military target, a terrorist. The problem was he was attending a wedding. And he was in the middle of the wedding. I mean, we were watching it real world on camera. And the decision to the commander was, do I launch the Hellfire missile or I do not? Of course, it's a command decision to use force. It's the legal advisor just says, here are the rules, it's your call. I advised, no, that you should not take him out because you will kill everybody at that wedding. And that was an indiscriminate act and therefore potentially could get us into a war crime. And so the commander chose not to take this guy out. So that is just a real world example of how these principles actually play out in professional armies, particularly in NATO, when they're looking at targeting. So again, going back to the hypothetical related to that communication center, is you have take a particular missile system, and they have this capacity to literally take out that piece of that building and take out that communication center, as opposed to, and if by chance there is collaterally harm done to civilians, they didn't intentionally target civilians, which is a critical aspect of the laws of armed conflict. You can't intentionally target civilians. If collaterally there are civilian objects and civilians killed, collateral damage is another principle which it does not make it a war crime. So you can see here where this mass destruction aspect of how the IDF enters into a particular military objective is really hurting itself, not just from a legal point of view, but it's turning what used to be an amazing, wonderful democratic gem in the middle of the Middle East into a pariah state because of this lack of ignoring the laws of armed conflict. And it has turned the world against Israel just because of how they attack a particular military object. I don't want to go too far down the road, but I hope this gives our listeners and our panelists some discussion points that it is a very specific, it is demanded by international law that professional armies, and I underscore professional armies, do follow the laws of armed conflict, and there is a methodology by which they consider their military targets. And all professional armies have judge advocates who are in the targeting committee, who are in this decision whether to launch the attack, and they're reviewing these operations to ensure that they comply with the law. So we need to make sure that our listeners fully understand that there is a very sophisticated system within NATO particularly, but also other professional armies around the world, that they're bound to do these type of things using only a militarily necessary reason to do so. So again, I don't want to lecture too much, but anyway, those are perspectives of,
Thanks, David. We do have a question at the back of the room.
My name is Jakob Vizil, and I prepared the questions of this panel. And I've got two questions. One question is, does it seem reasonable to create an exact manual for military which would define a war criminality of
A manual that tells people exactly.
Can it be a precise manual that is like, the Declaration of Human Rights are valid for everybody in the same way? Of course, there are different interpretations. Can it be put down more precisely? Just mentioned the clear rules of NATO military members. And the question is if there could be a general manual for everybody in the world. Second question connected to that is, Netanyahu said in an interview, I think on television, well, you always have civilian casualties in war. And he said that he presented on television as a success that the ratio of killed Hamas fighters to killed civilians had been improved by the IDF from 1 to 1.5 to 1 to 1. Basically saying that less civilians are being killed in ratio to how many Hamas fighters are being killed. How do you see this, specifically asking David Crane and Geoffrey Robertson?
Well, it's a very good idea in theory. You've got to remember that in practice, there are great differences, even between lawyers of different nationalities. Think of the bombing of Belgrade. The Americans had their lawyers, the British had their lawyers. Cluster bombs, the British were happy to drop all over the country. The Americans said not. That's a war crime. You think of the bombing of the television station. Oh, said the Americans, it's a propaganda for Milosevic, bomb away. No, said the British, it's got to remember free speech. And there were many disagreements. So, of course, it ought to be a case of a NATO manual where these different views are agreed, and it would assist. But on the essential question that we has driven so many people to want a different law, we have to decide, is it a crime to order a bombing attack on urban areas which will inevitably kill civilians, even though you may not want to, if you have knowledge that it will certainly kill large numbers of civilians? Do you commit a crime? And if so, what do you need to have up your sleeve as a reason for doing it? And as a defense, is there a defense for such a large-scale bombing that you know will kill hundreds, if not thousands of civilians? So I think these issues must be solved before the manual, much as it's desired, can be written.
Well, actually, there is a manual. It is followed. What I've been talking about is a standard that is known throughout all of the countries that sign on to the laws of armed conflict, specifically the Geneva Conventions, etc. And so, what I'm talking about is a standard. Now, certainly in circumstances, combat circumstances and stuff, the fog of war causes wrong decisions as well as right decisions. So I'm not defending any of this. I'm just laying out what a specific standard is, so that, and this is a standard that is trained in NATO. And so if a judge advocate, or actually it's a command decision to launch an attack, if the commander chooses to ignore or to go ahead and not attack based on the law, that's the commander's decision, but he opens himself up potentially for investigation, because another standard is within the laws of armed conflict is if there is a allegation of a war crime, then the combatants have an obligation to investigate and prosecute or hand over to another party the person who committed the war crime to prosecute. So that's also a standard which I'm just laying out. So I think that's kind of important, to discuss the second portion of the gentleman's question. Now he's saying, well, civilians die in combat, kind of flippantly kind of just tosses that out. Yes, they do. But there is the bedrock cornerstone principle of the laws of conflict says civilians cannot be intentionally attacked. Now, if you choose to ignore that, you do that at your own political and legal peril. But the point is that is the standard, and all parties know that. So, just to flippantly say, well, the civilians get killed, yes, they do, collaterally as well as specifically. Collateral damage is not considered a criminal act. Violations of the principles of military necessity, discrimination, etc., are war crimes, and so a commander or a political figure does pay that price. So I really, the tongue-in-cheek approach that he used in that particular news conference related to mass destruction of Gaza, I thought was really a discredit to Israel related to how it approaches the rule of law, which really does govern the horror of combat on the battlefield.
There's another question at the back.
Yeah, hi. My name is Sarah Finn. I'm an assistant professor in international law in Radboud University here in the Netherlands. I had a question about the relationship between the law of armed conflict that we're talking about in this panel and the law on the use of force, because it kind of relates a bit to what Alice just said, or said a few minutes ago. How do you see that relationship? Because for me, and I think the kind of standard public international law answer is that they are completely separate. But one of the things that I have found most frustrating in a lot of the coverage in this conflict is that there is a suggestion that if Israel has a right to self-defense under the law on the use of force, that has implications for what they can do under international humanitarian law or the law of armed conflict. Whereas I think it's as if I would say that those two things are completely separate. They may have a right to self-defense. They may even have exercised that entirely proportionally, but that has no implications for whether or not they violated international humanitarian law. So I was wondering how you understand that distinction, but also whether you see the merging of those areas of law in your work, and if you think that's problematic.
Is there anyone specifically you want to pose the question to, or just to the panel at large?
To the panel in general.
Okay, could everyone online hear the question?
I'm afraid I didn't.
Okay.
She was breaking up, and so I'm going to have to defer to my colleagues who heard the question. I'm going to repeat it, but I can't comment. I only caught about half of it, but thank you.
Okay. So the question was about the relationship between the law of armed force and the law of international law, and how they've been sort of broadly conflated, but is it really appropriate to do so?
The law of armed conflict and the law on the use of force.
And the law on the use of force. Sorry, the law of armed conflict and the law on the use of force.
Well, again, we have to go back to the concept of the UN paradigm, the UN Charter that says, and this is the cornerstone aspect of the UN Charter, is we settle our disputes peacefully and only use force as a last resort. So that's the international standard. We do not automatically defer to war. We try to settle our disputes peacefully. From a practical point of view, from a altruistic point of view, that's a wonderful concept. Practically speaking, that has not worked out exactly, but that is the fundamental part of the UN Charter. So that gives the fundamental jurisprudential cornerstone to dealing with violations of international peace and security. So that broadens, and then we start narrowing within that. We have a body of law that's been around for about 5 centuries that is now morphed into what we would call international humanitarian law. And I think Jeffrey makes an interesting point about humanitarian, but that's what we call it. And then a subset of this is the laws of armed conflict, which have been around in some form or another for about a century, going all the way back to the Red Cross movement with Henry Dunant, the Swiss humanitarian at the Battle of Solferino, saying, my God, we have to do something. We have to protect people found on the battlefield. And so you see the beginning of the Red Cross movement, which is also the protector of the formal protector of the Geneva Conventions. And over time, one of the principles is that all armed forces have to be trained in the laws of armed conflict. So that is a requirement of armies. Of course, we don't see that in rebel groups and non-international armed conflicts, of course, but we have professional armies have to be trained. In fact, I was one of the drafters of the U.S. Department in My Lai in Vietnam. The political decision was made is we cannot have any more My Lais. And so we created the DoD Law of War program, which essentially requires all members of the armed forces to be trained in the laws of armed conflict, all aspects of it, and to conduct their military actions based on that. And if commanders choose not to, they are prosecuted under the Uniform Code of Military Justice. So that's the general four corners framework. So, and we do have an extensive body of law around all conflict, even in the 21st century. And my point earlier is that we are tragically drifting from this, and I think we've been kind of tossing this back and forth on the panel, is that even though we have these rock solid standards, at the end of the day, and in ways that we've been kind of alluding to, these dirty little wars that I call them, the parties are drifting from those bedrock principles and shaping and molding the combat in a way that's politically acceptable to them. And Netanyahu, from the Israeli point of view, has done just that. He's taken he's basically ignored largely the laws of armed conflict and shaped and molded the message in ways that are really politically destroying the credibility of the state of Israel just by these actions. In Gaza, of course, the Russian Federation is a pariah state now based on their widespread aggression against a UN member state, Ukraine.
What do you think of that, Sarah? You don't have to respond.
Yeah,
You're welcome to.
It wasn't quite answering the question, but then it didn't hear the question very well.
Yeah, did you want to repeat the core aspect?
I can.
Yeah, sorry.
I can come in also, and maybe I do think he was addressing the question in some way. I mean, and I can bring it to maybe apply to the facts a little more. I think it's a very interesting question, and I think the conflation of, I guess, jus ad bellum and jus in bello, like in Ukraine, is probably the most obvious and plain example of this, where Russia has no legitimate military objectives in Ukraine. So I think when there's a lot of conflation of the law of war and war crimes when it happens in Ukraine, it's a little bit absurd, right? Because you can't talk about these military necessities in Ukraine. And so that's why the focus on aggression makes a lot more sense. And I think it goes to the absurd end is that, you know, Amnesty International maybe puts out a report really condemning Ukrainian forces for operating out of civilian areas. But it's like where else do they fight from? I mean, it kind of gets, yeah. But when it comes to Israel, Gaza, it's very interesting because there are different objectives. Returning the hostages appears to be the most legitimate military objective, but Israel also has declared its intention to destroy Hamas as a political entity, and that seems a little more debatable as to whether or not that falls within the realm of self-defense. I think it's a question of, on October 7th and the following days and weeks, at what point did the threat end within southern Israel? At that point, maybe the question changes as to, is this still self-defense for our people? And whether it's only about the hostages. But I think, as David mentioned, the UN Charter outlines, and this kind of brings it back to my earlier points about how the Pacific settlement of disputes should be prioritized over the use of military force. And, you know, the international community should think about all ways to do that. And like I was mentioning, maybe sanctioning companies that are supporting the Hamas leadership, or incentives that encourage the Israeli government to continue this. When we talk about the release of the hostages, and of course there could be a debate about this, but you know, around 130 were released in an exchange, right, with prisoners, not by the use of military force. Some people might claim that the use of military force led, but ultimately what we're talking about here is, and what Israel declares is that it's trying to use force so that Hamas and the Palestinian people will never rise up again, which is a pretty absurd, it has no like scientific, it's the brute use of force to deter, and then deter other Hezbollah, etc. And so, to go on for so long without thinking about how to effectively maybe release hostages through a pacific and peaceful means of diplomacy, and how to bring the parties to the table in Qatar, let's say. And so that's all I'll say about in terms of, that conflation. But I think it's a very interesting question.
I think your question actually had an instant unthinking response for me, that the history of this area of law, whether you call it war law, humanitarian law, the law of armed conflict, it's all about the same thing. And we've seen over the years the best way of progressing is to avoid the old pettifogging distinctions, to avoid the use of Latin, in particular use belli and use bellum and so on. I've never understood the difference, and nor does the man and woman in the street, because we are now talking about a criminal law, and it is the basic requirement of any criminal law that it should be understood by criminals and not by international lawyers. So simplicity is the best. And the old arguments, for example, about whether war crimes against humanity can be committed in peace as well as war, which went on for years until the Tadic case resolved them, and other quibbles and disputes are simply best to be avoided. And we have an area of law, whether it's called the law of armed conflict or humanitarian law, whatever, which deals with standards of behavior in war. And the sooner we have a few precedents for prosecuting or defending the war crimes that we see in front of our eyes on television, the better.
Yes, we're sort of coming up to the end of the panel, and I guess in that nature, I wouldn't mind speaking to perhaps the ostensible end of the end of the conflict, or at least this, perhaps not the broader conflict, but this iteration of heightened conflict within Gaza. Again, I am an AI scholar, so I'd be remiss if I didn't have one question in here about the nature of gathering evidence at the end of this, once we're going into the rubble and trying to work out exactly what happened. An event that I found extremely interesting to witness was the bombing of the Al-Ahli hospital and the way that that was reported worldwide, and the incredible day-to-day seeming differences in facts that were coming out, and certainly about where you were getting your facts. You were receiving very, very different facts. The Western media reported the bombing of the hospital extremely differently to how Middle Eastern media was reporting bombing the hospital, and then social media with another ballpark again, where you had an enormous amount of information. Both sides to the conflict accused the other of creating false video, false statistics, false synthetic content. The Israelis accused the Iranians of running a mass media propaganda campaign. The Iranians and the Palestinians, of course, accused the Israelis of doing the same. And at the end of that whole conflict, depending where you were, the final consensus as to who bombed that hospital came out on very different sides. So now a large number of people believe the Israelis bombed the hospital, and a large number of people believe it was a misfired Palestinian rocket. In the nature of this, and now we perhaps have a changing standard where now the video content can be manipulated to be extremely convincing. That might even change the evidentiary standard of, traditionally, if someone was a witness to something, you would find a video of the event would be stronger evidence than someone just saying, I was there, if you saw a video that showed something else. Maybe that will change if video becomes less believable or less legitimate as a source of reality. We might go back to going, well, 20 people said it happened this way, and maybe this video, we can't authenticate that it's real. What do you think, and I guess anyone in the panel that has the strongest opinions on it, are going to be the core challenges if this conflict ends, as many people suspect it will, with Israel setting up some sort of military standing and kind of presiding over it and trying to form a new government over Gaza in the rubble of what's left of Hamas? What are going to be the core challenges in evidence? America says that it's illegitimate, the trial, and if Israel says the trial is illegitimate, saying that, what are going to be the core challenges about presenting that case and coming in the aftermath?
There'll be no difficulty because the ways and means have long been established in Argentina and the Balkans and so forth of doing, investigating the mass graves. But what we want to know is what are the intentions of those who are charged with crime. And that will involve getting access to the papers. Nuremberg succeeded, as Robert Jackson immortally said, because of the Teutonic habit of writing everything down. They had Goering's signatures on the night and fog decrees and so forth. So it's really getting into the meetings of the Israeli war cabinet in terms of Netanyahu and Gallant to see what was said, who heard it, and so forth. That will be the major difficulty in that particular case. I don't think the difficulty will be as great in the Hamas people. I know you'll have to show that they did hold leadership positions and determinant positions in relation to orders to those who carried out the atrocities.
You know, one has to prove that each and every element of the crime beyond a reasonable doubt. So that hasn't changed. We do have solid rules of evidence now that have been put in place and in practice for well over 25 years. But the bottom line is that we have to lay a foundation and show the relevance of that particular piece of evidence as the prosecutor is trying to prove an element of a crime in order to get a conviction. I think it's harder today than it was even when I was in West Africa because of the mass amount of data. What we see here is it's just data. It's not even criminal information. It's just data floating around social media, the web, the internet, to the multi petabytes of data. I look at it as more of finding a piece of evidence, a needle in a haystack, in order to have a valid piece of evidence that I can go before a tribunal and offer that as a piece of evidence, so that even though we tend to think that it's have all this data out there, these videos, these pictures, these interviews, these TV programs and stuff, none of that is admissible into evidence. We have to go and actually create a foundation enough to, in fact, do that. And you're into artificial intelligence, and you certainly understand that we have to really peel back another onion, which we didn't have to do in West Africa. And that is going to the metadata and stuff. We have to show that that video actually was taken to show a particular crime. And if I can't do that as a prosecutor, or if my trial counsel can't do that, under our current rules of evidence, and they may have to evolve, and they probably will, but under current rules of evidence, I can't show the foundation, because I can't really show that's the particular video. And then, of course, you throw in the propaganda, and then the artificial intelligence, and you create a war crime that didn't happen to counter a particular allegation of another war crime. You can see that permutations of this would make your head explode. So I think it's harder now to, in fact, prove crimes, because of the amount of just pure data that's floating out there. It gives the false impression that we've actually proven this crime. At the end of the day, we haven't proved nothing.
We definitely don't have robust, reliable watermarking metadata.
I'll just, sorry, I'll just add before you wrap up things very quickly, because the main problem is, as everyone has pointed out, because propaganda and artificial intelligence will definitely make it harder. But in spite of that, we have to talk with the victims. We have to collect their narratives. And also, we have to collect the circumstantial evidences as well by visiting physically those places. Because as the day progresses, for example, if we start the trial 15 years or even 5 years after today, you will find out the ground is totally different. So when the victim is saying this hospital was bombarded, and then when you go and visit it, you will probably say that it is not bombarded, it is intact right now. And then the defense will claim showing at that time was actually right now. We have to, ICC wants to go ahead with the trial. They must collect the narratives of the victims and collect photographs and videos by visiting those places physically, because at the end of the day, it will be my narrative against their narrative, you see, and it will be quite tough for the prosecution as the day progresses. If we do not collect the evidences right away through a foundation, through a group of people, it will be really, really tough if we do it even 1 year after today. And definitely political willingness of every channel through which the victims are contacting the prosecution is very important, because the victims can be biased through different words, different offerings. So we have to have biasless victims, true victims, and if possible, direct witnesses, not hearsay ones. That's what I wanted to say.
Thanks for that, Tapas. We are actually biasless victims. That's going to be a tough one to find. But it's,
Turn your defendants into victims by hanging them.
Mhm.
Do you still do that as prosecutors prosecute so they're hanged if they're convicted?
We are over time, unfortunately, but thank you so much to all of the panelists. It's been a great panel, and we're going to go get lunch and then come back in for the second half.